Bismillahirrahmanirrahim. My name is Abu Bakr Nauman and I am serving as Deputy Prosecutor General Punjab. Over here I am taking care of the duties of Deputy Director CPD. This module encompasses an understanding with regard to scrutiny of challan in GBV cases and an understanding with regard to application of full code test in GBV cases. Most appropriate and most powerful tool which is within the prosecutorial arsenal is the application of full code test. This happens at the stage of scrutiny of challan when the compilation of evidence under section 173 CRPC is presented before the prosecutor for its assessment and to rectify the weaknesses or wrongs in the collected evidence. Basically, it is the prerogative of a prosecutor to select the witnesses, to select the substantive piece of evidence on which his case is hinging upon, and at this stage, he does not only abstractly and haphazardly affixes his signature on the challan, but he applies full code test, which is a prosecutorial assessment. It is different from that test of judiciary, which is establishing something beyond shadow of doubt. It is basically an assessment by the prosecutor whether the case possesses the feature of the success of case, which in specific terminology of the prosecution is called there are three terms used for a case. A case which is not likely to be successful is a case not worthy of prosecution. The case which possesses 50% chances of success and 50% chances of failure, that is called prima facie case. And the third one, the case possessing the feature of realistic prospect of conviction. By application of full code test, in all criminal cases and specifically in gender-based violence cases and sexual assault cases, prosecutor assesses whether a case touches the touchstone of realistic prospect of conviction and assesses all the evidence. For this, he applies the test, full code test, which is again apportioned in two parts. In evidential test, prosecutor assesses the case on three contours. Number one is the sufficiency of evidence. Number two is the reliability of evidence. And third is the defense perspective. In sufficiency of evidence, prosecutor chooses which evidence he is going to present before the court, which witness is going to forego, which evidence is essential and which is not essential to that degree. And if the evidence is deficient, he can issue directions under section 4 of Code of Conduct of Punjab Criminal Prosecution Service to the IO to collect further evidence. Then there comes the touchstone of reliability of evidence. Every evidence which is collected by the police may not be a reliable piece of evidence. For instance, in our criminal cases and GBV cases specifically, we prosecutors often witness sort of padding in the police case in form of extrajudicial confessions. And if an extrajudicial confession is made before the police officer and a joint confession is made, that is not a reliable piece of evidence and that is not even admissible piece of evidence. So prosecutor has to look from his vantage point onto these gray areas and rectify the weaknesses. Then another example of the reliability is this: if a third degree torture is applied and some statement is elicited and later on witness or accused in the court of law tells that it was elicited by way of torture, so it is not a reliable piece of evidence. And the third thing is a defense perspective. For instance, in our jurisdiction, there are often numerous delays in the lodging of FIR. For instance, a delay of 12 hours in a rape case. When the defense lawyer argues the case in the court, the first point he assails is this: that if this incident happened, why FIR was not lodged promptly. So prosecutor has to come up with plausible explanations that this was the reason. The distance from the police station was quite ample. It could not be told to the police there was no telephone network in the area on which the police could be set to motion, or they were trying to take hold of the accused on their own, etc. These are the things on which prosecutor abstractly determines that where his case stands and how it can be further fortified. Then comes the stage of public interest test, and in public interest test, the factor which is determinable is this, that whether this prosecution is in the public interest, whether the national exchequer and the time which the state functionary is giving to that particular case is worthy and in the interest of justice and in the interest of state. So the general rule about the application of public interest test is that all prosecutions are in public interest unless otherwise proved. There are certain public interest factors which have been enumerated in Code of Conduct, like being of extreme tender years of age, being of extreme old age, or being first time offender, being a female, committing a very trifling act, etc. These are the public interest factors. And after there is a thumb rule principle, public interest test shall only be applied if the evidential test is passed already. If the case is not worthy of trial in the eye of prosecutor, then there is no need of application of public interest test. Public interest test shall be applied only when the case is a prima facie case or a case of realistic prospect of conviction. By putting this test, basically prosecutor determines whether the case falls within the four corners of suitability with the state expense and spirit for which the criminal justice system has been developed. Thank you very much. Happy learning.